seat there. Hello. Colonel Gunn is also a career military lawyer, and should be required to proceed with military commissions, he'll be directing the entire defense team and also advising the General Counsel on all matters related to the defense. He'll also manage a pool of civilian attorneys that are being solicited by the Department of Defense for possible involvement in commissions. And he's here to talk to you about that process and take your questions.
Thank you. As previously mentioned, I am Colonel Will Gunn. I'm an Air Force lawyer. This week I celebrate 23 years of active military service. I'm an Air Force Academy graduate and a graduate of Harvard Law School. In my current capacity, I've been appointed as Acting Chief Defense Counsel for the military commissions. In that capacity, it's my responsibility to ensure that all detainees who are brought to trial before military commissions receive a zealous defense, receive zealous representation by defense counsel. That representation can be by military defense counsel and also by civilian defense counsel. In all instances, detainees brought to trial will receive representation by military defense counsel. However, if they're not satisfied with that particular military counsel, they can request other military counsel, and such counsel will be made available to them if that person is determined to be reasonably available. They're also entitled to be represented by civilian defense counsel, provided that is at no expense to the United States. I'll now take your questions. Yes.
Colonel Gunn, I'm wondering approximately how many applications you've received from civilian lawyers interested in becoming part of a pool of available attorneys. And also, I understand that you'll be responsible for ensuring that the civilian attorneys comply with certain rules and regulations, and I'd like to know how you'll go about doing that.
First of all, to date, I have not received any applications from civilian defense counsel. I do anticipate that that will change. Within the last couple of days, we received inquiries from the first two individuals. But I anticipate as a result of today, that's going to change a great deal. And could you repeat the second part of your question, please?
I understand that part of your role is to ensure that the civilian defense counsel abide by certain rules and restrictions on their activities, and I'd like to know how you can enforce those rules and be sure that even individuals that aren't associated with the military abide by those restrictions.
Well, going into the military commissions, any civilian defense counsel that desires to get involved and become a member of the pool has to sign a document stating that they are aware of the rules and they agree to abide by certain parameters. So they are going to agree to that, first of all. Secondly, though, if they fail to abide by those parameters, the only real sanction that I see presently is that they would be forbidden from taking part in commissions after that point.
And I think if you want to look at a good copy of what they'll be signing or agreeing to, if you take a look at military instruction number 5, that goes over the agreement they'll be signing.
Colonel, there's a concern among some legal experts that the rules for the military commissions are much more restrictive for the defense counsel. For example, that you don't get evidence until a week before trial. You don't. You're not as you're gagged almost. There seems to be some provisions for that, and that there are also limits on your ability to conduct your own investigation in the case. Does that concern you at all?
If those were in fact the rules, that I would certainly be concerned by that. But I am not under the belief that those are going to be the conditions under which defense counsel will operate in the system. Right now, no one has been brought up on charges. As a result, none of the detainees are represented at this point in time. But after a detainee is charged, then I anticipate a negotiation process whereby the defense counsel will negotiate with the prosecutors to determine when the defense counsel is in a position to provide an adequate defense. And that's going to be dependent upon the defense counsel conducting an independent evaluation of the evidence and an independent investigation of some sort.
And you don't see any problems right now the way the rules are written where you could have an issue with that does it appear at all restrictive to you at this point?
This is certainly a foreign environment in the sense that this is quite a bit different than the environment that I am accustomed to practicing in, and that's the military justice system of courts martial. However, with the rules as they're presently drafted, I am firmly convinced that we're going to be able to operate in such a manner that we're going to be able to provide a zealous defense for all detainees brought before trial. Yes.
Sir?
So you don't think that the rules, as some critics have said, strongly favor the prosecution? For example, the admissibility of hearsay evidence, the potential monitoring of conversations between defense counsel and the defendant. Some people have said a lack of sentencing guidelines, in terms of this conviction could lead to what, death penalty or 1 year in prison. So you don't think that any of those rules are beneficial to the prosecution and detrimental to the defense?
I believe what I'm concentrating on more than anything else right now is the fact that in order for the government to convict anyone, they're going to have to maintain their burden of proof. And that burden is that they're going to have to prove that an individual is in fact guilty beyond a reasonable doubt. I can guarantee you that the defense counsel that are being brought onto the team that will be assigned to represent individual detainees that are accused of crimes, that they're going to do everything in their power within those rules to challenge the government's case. We don't have a group of people that are just going to roll over and accept whatever is presented.
And if I could point out one thing too, you brought up the rules of evidence. One thing to remember on that same rule of evidence applies to defense as well as to the government. So there may be pieces of evidence that the defense will be able to admit to these cases that otherwise may not be admissible without the relaxed rules. So it's a pendulum that goes both ways.
On the rules, let me just follow up. Is there any provision in the instructions for a defendant to challenge the commission's to challenge his eligibility to be tried before a commission? For example, he argues, I am a prisoner of war. I don't belong here. Is there anything that allows such a challenge to take place?
I'm not in a good position to answer that right now in terms of how that will actually play out. From a jurisdictional standpoint, I see that as a fundamental jurisdictional question. And exactly how that will work procedurally, I'm not sure at this point.
I mean, that seems like it would be the first argument that someone would make is that I don't belong here.
One thing you have to remember too, though, there were prisoners of war who were tried during World War II under military commissions. So it's not really clear that just the fact that you're a prisoner of war doesn't mean a military commission could not be the appropriate forum.
Right. I'm just talking about someone making that argument.
Colonel, how do you envision this relationship with the civilian lawyers might work? I mean, how would one of your military defense lawyers be interacting with a civilian lawyer? And what would that civilian lawyer be doing inside one of these trials? I mean, how would any of that work?
Usually, in a military context, when a civilian lawyer comes aboard and becomes part of the defense team, that lawyer becomes the senior lawyer, and he is the head of the team. This situation is a little bit different in the sense that while that individual may become part of the team, there may be certain segments of a commission that person may not be able to sit in on because they may not have a security clearance that allows them access to that particular portion. So that's going to be a bit unusual. In terms of how it's going to work, I can assure you that both the military counsel and the civilian counsel are going to consult with one another in terms of determining what the trial strategy will be. I should also point out that in order for a civilian counsel to become part of the defense team, the particular detainee who is accused of a crime will have to make that decision that they want to be represented by civilian counsel.
The civilian has to be a U.S. citizen, is that correct?
That is correct.
May I just follow on to that security clearance issue? It seems to me that there's a problem right now in the Alexandria courts where this is becoming an issue with that particular individual. How can a member of a defendant's team possibly provide a proper defense without having a full knowledge of the entire scope of information that's available about that person. How is it possible that that person could be effective in defense with having a major chunk of the prosecutor's case unavailable to him?
It's entirely possible that for each individual case, there will be a volume of information that the government may have developed from an intelligence standpoint on that particular individual and activities that that individual has been involved in. However, in order for that to be of value inside the commission, the government is going to have to present that in some manner. There could certainly be challenges when members of the defense team don't have access to the same amount of information. What I can tell you is that members of the defense team are going to do everything in their power to bridge that, while at the same time being conscious of our limitations from a national security standpoint.
And one thing you have to remember on that too, one of the requirements is that a civilian attorney must be eligible for a secret clearance at the minimum. There may be civilian defense attorney who are eligible and actually obtain a top secret clearance. And if that's the case, they would have access to more information. So it's really going to depend on that individual's eligibility.
Accelerated clearance process associated with that, because it can take 6 to 9 months to get a secret clearance, much less a
And I
year.
think those issues are being worked out right now.
Sir,
I know it's difficult to say because you don't have a defendant in front of you, but generally speaking, what is your position on how much of these military commissions, once one gets underway, do you think is in the best interest of the defendants to have in open session where the public can see what's going on? The concern, as you know, I'm sure, is that people think that these military commissions are going to be completely secret, and the Defense Department keeps assuring everybody that that's not the case. But what's your position, sir, on how open it should be to help the defendant?
Recently, I was reading an excerpt of an article by Lloyd Cutler, who was the youngest defense counsel or youngest prosecutor in the Enrique Quirin case, where we had the German saboteurs during World War II that came ashore and that eventually met a military commission. And he was talking about the military commission process that was being developed at the time that he wrote the article. And he was also talking about that process, and he commented on the fact that a great deal of it was, well, all of it was conducted in secret, and the press was merely briefed on it. And he looked at it as a mistake. I agree with that to the extent that this process is as open as possible within the constraints of national security, that's going to be in the best interest of not only the detainees, but more from a broader standpoint, I see that as in the best interest of the nation as a whole, because this process is going to be judged not so much by virtue of whether or not a particular detainee was convicted by military commission. It will be judged from the world community by virtue of whether or not the process was fair and just. And as a result of that, you and the press play a vital role in helping to accomplish that.
May I ask a question? Earlier, the incoming acting chief prosecutor had said that you had a real zeal to make certain that there will be a fair trial. I wondered your thoughts about that, and what happens if, in fact, you don't get the information that they have, the reams of information that they have? Will you argue that that won't be a fair trial? What are your thoughts along those lines?
First of all, in terms of my personal zeal, let me just say that this is not a position that I sought out. When I was contacted about taking on this position, I immediately recognized that the glamour position here was that of chief prosecutor, the opportunity to be America's hero. But as I reflected on it, it occurred to me that there is a valuable role to be played by defense counsel, a critical role to be played by defense counsel, again, not just for the individual, but also for the nation as a whole. And I looked at my background, I looked at the experiences that I've had and opportunities that I've been presented with, and I said if offered the opportunity, then I would go for that. I would accept it because of the opportunity to serve. In terms of not receiving all the information that's out there, I can assure you that defense counsel that are part of this process, one of the things that we're doing in order to screen for those people is we're looking for fighters. We're looking for people of sound judgment, of high integrity, who are going to do their jobs to the utmost of their ability. And their job in this context is to represent individuals. And I can assure you they're going to do that.
You mentioned a couple of civilian lawyers have expressed interest. Yes. Can you say who they are? Is there anybody of note there, a Harvard professor or a celebrity lawyer?
I don't think it would be appropriate to talk of any names at this time. After applications are put in and when the time's appropriate to announce who counsel may be for individual cases. And again, it's going to be the accused's choice whether or not he wants someone to represent him who's a civilian. So I think it's a little premature to be talking on those issues right now.
So far, only a couple have expressed interest?
Exactly.
Are they offering to go pro bono on these then, since most of these people, I would imagine, can't afford to?
Part of the application process will require them to identify whether or not they're willing to represent individuals on a pro bono basis.
Can you just classify them in general, like there might be some big names, or or they have a long history, just in general?
I think we'll just leave that at where we did. But, this gentleman over here with the ties had his hand up for a while.
There's obviously a finite pool of potential cases. Are you looking at them at all, doing any kind of preparation in case some of them actually, the president does make a decision that the process will go underway?
The individuals who are part of the acting Chief Defense Counsel's office right now have been working to look at the instructions as they're drafted so they can firmly understand that system. They've been doing other types of basic research, both from a historical standpoint as well as from an international law standpoint, so they can understand the context in which they're working. But again, since there are no cases actually before us right now, we don't have the ability to concentrate on a particular individual in a particular body of facts.
Colonel, as a uniformed member of the U.S. military, and knowing what these folks have been accused of in this building, in New York City, and around the world, how can you and the folks on your team really generate the passion to feel that these people deserve to be defended, let alone to actually go in to work every day for as long as it takes to defend them, and in that zealous way that you talk about? I mean, as a human being, how do you personally work your mind around that issue?
We do that, first of all, because we believe in this country, and we believe in what this country espouses as its key values. And among those key values is the concept that every individual accused of a crime is presumed to be innocent. And so from that standpoint, defense counsel play a critical role with respect to that. We've all represented individuals that others may have despised, others may have been leery of, but we had a job to do in a particular situation. And sometimes you discover that despite how things may look on the surface, as you get into them and as you explore the facts, and as the light of the judicial process focuses in on an individual, you find that things aren't always as they seem. And so that's the value. We have a job to do. We believe in this nation, and we believe in what this nation espouses.
Along those lines, Colonel, you mentioned early on that you thought that after today, I guess after some publicity about this, that there would be more applications from civilian lawyers. These are people who may have the same feelings toward the country you have, but you said that one of your reasons for doing this was to serve the country, and these are civilian lawyers. So what would the attraction be, especially since you concede that probably the glamour job is on the other side? What would draw a defense attorney to want to be part of this?
I think that's really something you would have to pose to them. I think different people are.
The Colonel did say that you thought after today that would change. What about that? Why is knowing about this process likely to draw more people in?
Well, already as a result of information about the commissions being in the press, we've seen articles by people in the academic community, and in other sectors that have commented on the rules, that have commented on the wisdom of utilizing military commissions. There are some people that are interested in the process from an intellectual standpoint. There may be some people that are interested in the process largely because they also share the belief that if this is done, it has to be done right. And in order for it to be done right, it requires people of integrity operating within this system.
The lady with the black.
Both the Chief Defense Counsel and the Chief Prosecutor report to individuals in the General Counsel's office of the Pentagon. I'm wondering how that's different than the structure of the Judge Advocate General Corps of the various services, and what mechanisms have been set up to insulate defense attorneys from any of the political pressures that might exist in the General Counsel's office.
That is a matter that we've spent a great deal of time talking about. First of all, from the military justice standpoint, a military defense counsel at the lowest level works for a chief defense counsel who generally works for a chief of defense services within the service, who ultimately works for that service's judge advocate general. And within this system, an individual defense counsel will work for me or whoever is occupying the position of the chief defense counsel. I will report to a deputy general counsel who reports to the general counsel. So ultimately, all roads lead back here to the Pentagon, whether you're talking about the military justice system or whether you're talking about this system. However, that road is a lot shorter under this system. So here, what is really going to take people of high integrity, for one thing. My commitment is to fight to make sure that the defense counsel that are part of this system are free from improper influence or interference in doing their jobs correctly. And we understand perfectly that one basic reason for military commission is to protect national security. But I believe that we can operate within the system, the interests of national security can be protected, and we can have a zealous defense function in which defense counsel are free to do the job that they need to do.
I think we have time for 2 more questions. Ma'am?
Do the civilian defense counsels have to pay for their own security clearances? And if so, do you know how much that would be?
They do have to pay for their own security clearances, but I don't have the information on the amount.
And some may already have their security clearances from either being in the service or some other branch of the government as well. And take a final question from the gentleman with the white shirt.
Pardon me if you've answered this before. I missed the top of your briefing. How are you preparing for these upcoming trials since you've been assigned to this? How are you preparing? Are you looking at past cases from past wars, past conflicts, or are you taking theoretical situations that might be coming up and essentially wargaming or what? How are you preparing for what's coming up?
In a general sense, you could say that we're doing a little bit of all of that. We're making sure that the defense counsel, first of all, we have defense counsel that are very experienced, who we anticipate will be part of this team and who will represent individuals that are actually accused of crimes. And to the extent that there are aspects of the process that they're not familiar with, then we're going to do all that we can to ensure that they receive training in those areas. They're reading the law review articles that have already been published that deal with military commissions. They're reading the press reports, and they're looking at such things as the sentencing guidelines, which is a foreign concept under the military system, but which is very familiar to people within the federal defense system.